I'm getting divorced. I hate the state of New Jersey and I want to leave. Can I? The answer is that is one of the biggest legal challenges I have in a divorce. Removing children from the state of New Jersey requires either the consent of the other parent or a showing that this move is not harmful to the best interests of the child. That is a tall order. It's not simply, wow, my company has an office in Los Angeles. I want to move to Los Angeles. I have better job opportunities there. Or I'm divorced already. I'm now engaged and my new spouse lives in Houston. Why can't I take the children to Houston? It's not that simple. Absent consent, you're going to need an order from a court that allows you to move. And this is an arduous process, months in the making, maybe a year in the making before you can relocate. And you might say, well, I am free. Am I not free to live anywhere I want in the country? For that matter, can I live anywhere I want in the world? You absolutely can. And I've heard judges sort of tongue-in-cheek say to a parent, you are free to move, but your children are not. Think long and hard before you decide that you are going to transfer your job or move to a state where your soon-to-be new spouse lives already. You have a large hurdle to overcome in removing your children from the state of New Jersey. And guess what? That includes right across the Hudson River to New York. You would think Manhattan is closer than Cherry Hill, New Jersey from northern New Jersey. It's still outside of the state. And I've had full-on trials moving a family from Hudson County to Brooklyn. It's not that easy. You're getting divorced in New Jersey and you have assets in other jurisdictions. What law governs? New Jersey law is going to govern. So you're living in New Jersey. Your spouse has moved to Los Angeles and purchased a home there. You also have a vacation home in Florida. What happens with all of those assets during the course of the divorce? The judge is going to look at, or a mediator is going to look at, the value of all of the assets, irrespective of what state the asset is in. And we equitably divide the assets. That doesn't mean I get the house in New Jersey, my spouse gets the house in California, we sell the house in Florida. Maybe that's the outcome, but those assets might all be valued differently. And we've got to equalize the values if we're doing a pure 50-50 split. The law in California will not govern. So while California is a community property state, it doesn't suddenly morph that asset into community property. Instead, the equitable distribution laws in New Jersey will govern because the divorce is taking place in New Jersey. And footnote, the same holds true with assets outside of the country. Although it's a more complicated conversation, the judge will want to look at the totality of the assets that the family owns, irrespective of where they're physically located. Alimony and relocation, does it really matter? It depends. The reality is that when you're setting an alimony number, the statutory factors, one of them is the need of the financially dependent spouse. So I'll give you an example. New Jersey divorce, one spouse moves to Texas. There's no state income tax in Texas. And in this particular section in Texas where the spouse moved, the cost of living is significantly less than it is in northern New Jersey. Does that spouse now need less alimony because they live in Texas versus if that spouse stayed in New Jersey? Creative argument, I certainly made it. These are all factors that you want a skilled lawyer to look at in assessing how much alimony, the appropriateness, because there's no formula for alimony. No matter how much you read that on the internet, I promise you if you look at the statute, there's no formula in the statute. It is all driven by the factors and the particular facts in your case. I've been divorced for several years, and now I want to take the children, because I have primary custody of the children, to another jurisdiction. Can I? Not so fast. Does your former spouse consent? Checkbox 1. If the answer to that question is no, you must file a motion with the court, a motion to relocate. And I promise you, this is probably the hardest motion to file in the state of New Jersey. Hardest in terms of the standard and the time. You need to show that this move is in your children's best interest. It's in their best interest to uproot them from the state that they've lived in. It's in their best interest to uproot them from their school, their social activities, and likely their extended family on the other parent's side. You may need a custody expert to come in and say that this move is in the best interest of the child. You need to show how you're going to replicate the amount and the quality of the time that your child spends with the alternate parent now. How do you do that if you're moving clear across the country and the other parent has the child or children every other weekend? I don't think you're going to fly them back and forth. We also have to factor in the age of the children. If I have a very young child, travel becomes that much more challenging. And who's paying the cost of the travel? These are just some considerations when you want to relocate post-divorce. Relocation presents difficult challenges in a divorce. It also presents difficult challenges post-divorce. Removing children from the state of New Jersey is not simple. Absent consent, you must obtain a court order, even if the move is to a neighboring state like New York or Pennsylvania. You still need consent or a court order, and you're going to need a skilled legal team to help you navigate this process.